Thank you, Michael, and good morning, everyone. I'm Brian Landry of Saul Ewing LLP, and I will be moderating this first episode of the Financial Poise Intellectual Property 101 series entitled IP, What Every Lawyer and Every Client Must Understand. Financial Poise seeks to provide practical and entertaining education for participants with a variety of backgrounds. Joining me are Alan Grafman of All Media Ventures, Patrick Riley of Spike Dynamics, who I believe is experiencing some technical difficulties and will be joining us shortly, hopefully, and Alexandra Svensson of Much Shell SPC. You can read our bios on slides 40 to 43. Neither Financial Poise nor we intend for this to be an infomercial, so you don't have to listen to me read bios. If you want more information about us, just look at our slides. I'll try to call your attention to slides relevant to whatever we're talking about, so you can take notes if you like. Don't worry if you're listening but not watching this webinar, you'll be just fine because the slides are not critical. Before we get started, I would like to thank our co-producer of the National Law Review. You can read more about the National Law Review on slide 3. Financial Poise webinars are supported by, in part by sponsors. The sponsors for today's webinar are Type to Learn and Max Asset. More information is available on slide 5. Last thing before we begin, slide 5 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and is not for you to act upon without appropriate advice. Without further ado, here we go. So Alexandra, as a small business owner, everyone keeps telling me that it's important to protect my intellectual property. To begin, can you help us understand what is intellectual property?
Sure. So intellectual property is actually an umbrella term that identifies different types of legal rights in things that people create or invent. And quite oftentimes, I think some of these terms can be used colloquially differently than their actual legal definitions. So typically, IP includes patent, trademark, copyright, and trade secrets. And each of those IP regimes applies to different types of things that you can create. Sometimes there can be overlap, but generally they apply to different types of things and they serve different purposes.
Great, thanks. Alan, when we were talking before this, you had mentioned some other types of IP. Do you want to discuss those now?
Sure. In addition to what Alexandra just mentioned, the 4 primary types, which is the focus of our conversation here, the copyrights, trademarks, patents, and trade secrets. And I can speak on that a little bit more. There actually is a 5th, which is less well known, and that's the right of publicity. That's very much state-driven, and that's, of course, only relevant where you have a high-profile personality who is used to monetize some sort of product, and they abuse someone else's personality. But that's a less well-known, and that is state-driven. The ones that Alexandra just mentioned are the primary ones, and I can continue on that, Brian, if you'd like.
Sure, go for it.
Okay. So the one that I'm most familiar with is copyrights, because copyrights protect intellectual property that is expressed in an artistic way. An artistic way, it could be literary, it could be possibly dance, it could be possibly not only written, but also an occasion, I want to be careful here, music also. So that's the one that I'm most familiar with and I can speak to. Trademarks primary purpose is to identify a product and its source and to remove confusion from the market. And people protect their trademarks vigorously because they don't want someone buying a product that is not the product they think they're getting, and trademark protections are significant. Alexandra also mentioned patents, which are quite involved and identify new processes or new novel inventions, and that has a whole separate strain. And then the 4th being trade secrets. Trade secrets are also less well known because those are internally kept secret. And that identifies a process used in perhaps manufacturing that allows a company to have a competitive advantage. So in addition to the 4 that Alexandra identified here on this slide, there is a 5th, right of publicity.
Sure, and I could even add a 6th to that. Design rights are kind of an interesting species that's almost a bit of a hybrid between patents where they're treated in the United States and I believe the Philippines, and trademarks where they're considered in much of the rest of the world. Really, that they're focused on the ornamental features of products. But I mean, just to use my iPhone as an example, often a very valuable IP right, because when you see an iPhone, even in its early days, they can have very distinctive designs that can signify a source before trademark rights may take hold. Alexandra, why is intellectual property important?
It is important because we live in, an increasingly knowledge-driven economy, and it is a vital incentive for companies to invest in innovation and in artistic creation, and it allows them to really monetize that and to possibly also recoup some of their R&D costs. So, I think a prime example of this is drug development, and it can take 20 years to bring a drug to market. And so, having some type of IP protection to recoup some of those R&D costs can be incredibly important for drug companies to be able to continue in that type of innovation.
Absolutely. And drugs are a really great, pharmaceuticals are a really great example of that, especially because I'm certainly not a chemist, so there's a bit of a gloss here, but my understanding is that once somebody identifies a compound, it's fairly simple for somebody to copy that in the patent sense, not in the copyright sense, and bring a competitive product to market. But there's certainly a lot of work that goes into, a lot of work and a lot of investment that goes into actually discovering a drug that works for a particular condition, and then actually doing the extensive clinical trial and safety work that's necessary in order to bring that to market. So there's a constant economic debate really going back to our founding as a nation and continuing to this day in various calls for IP reform of how do we get those incentives right so that people want to make the investments that we need in order to have next generation treatments or next generation electronics products versus allowing others to eventually compete in that market space.
Hey, Brian, I want to add two things to
Sure.
what Alexandra mentioned. There are studies that are done depending on your sample size, whether it's Fortune 500 or whether it's larger. There are studies that advance the thought that a majority of the public market value of, again, the Fortune 500, Fortune 1000, is the intellectual property that they possess, and it's not the factories, it's not the hard assets, it's the intellectual property. There's a firm that does a study every year, and they continue to advance that as part of opening up that concept. So it's something for people to be aware of. I want to add one other thing here before it slips my mind, because I just read that artistic creations that created by artificial intelligence cannot be copyrighted. And this is a real frontier type of issue, which is either behind the curtain or in front. Obviously, it'd be hard to prove that something was artificial, but you do have companies announcing that we're doing a movie created by artificial intelligence. And based on some based on the reading of the statutes, one could argue that it is only artistic creations from a human being that can be copyrighted. So again, that's a little bit behind the curtain, but I did want to add that.
Great, thanks. To pick up on what Alexandra was saying regarding patent process, I'll discuss a little bit about what it takes to get a patent. So patents are available for inventions that are new, useful, and non-obvious. Unlike some other forms of IP where registration is not essential, the patent process is an area of IP where it is absolutely critical to file with the appropriate office, in this case, in the United States, with the United States Patent and Trademark Office. And unlike other forms of IP, I'd say patent prosecution is probably the most rigorous, certainly the most expensive in most cases, examination process. It's certainly beneficial to consult promptly with a patent attorney after you develop an invention, because there are time bars where if you develop an invention and then publish it or commercialize it, you can either lose or substantially impair your rights, especially outside of the United States, where many jurisdictions are what we call absolute novelty jurisdictions. So if you create an invention and then publish it on a blog or in a journal article, you may have lost your rights in most of the world, even though you might have a grace period in the United States. Even within the United States, we have now moved some 12 or 11 or so years ago to what we call a first inventor to file system, which means that if I invented an invention and then Alexandra independently and without access to any of my information invented the same invention, and she files before I did, even though she may have invented after, she would be eligible to obtain a patent, whereas I would not. And then finally, once the invention issues, the term in the United States is generally 20 years from the date the application was filed. There's a bit of nuances around that, but that's the rough order of magnitude that we provide protection for here. So Alan, how do I find out if my invention's already out there?
So recall that for patent to be issued in the first place, it has to be novel, it has to be new, and it has to be something that produces something that has not yet been seen before for it to be filed. Generally, what people do is they search for previous expressions of that invention. People usually start on their own, and then they will hire a firm or an attorney to do a search. You can also, as I understand it, they can also search the files of the PTO, the Patent and Trademark Office. But generally, it starts with a wide search of what is out there to see if they have a patentable idea or invention.
Yeah, and there's, depending on the area of art, there's a number of different area or tools you can use for that. Increasingly, general internet search engines like Google can be very helpful. There are more specialized patent-focused engines like Questel Orbit, which can do some really powerful similarity searching or searching based on assinees or other information, including patent classifications. And then within the chemical or biological space, there's various specialized databases that are optimized for doing chemical structure searches or sequence searching if there's a DNA or an RNA sequence involved. Alexandra, how do I obtain, I often see people say patent pending on their product. How do I obtain that protection?
Sure. So as you mentioned, patent protection for utility patents generally lasts for 20 years from the date of filing, but the prosecution process can take a really long time. And so while the patent is being reviewed by the patent office, you can file for something that's called a provisional patent, and that gives you protection for 1 year while your patent is under review. And so you want to make sure that during that time period, you continue to aggressively pursue your utility patent application to make sure that once the provisional patent protection expires after a year, you don't have any gaps in protection.
Great. And in our experience or my experience as a patent attorney, we see a real variety of provisional applications. And one of the areas that we often talk about with our clients is the role of a provisional. And because provisionals sit there for a year, oftentimes clients can take different or sometimes don't make as rigorous of an application as they would if it was a non-provisional application, where they know the USPTO is going to look at that. But in the best scenario, we really like to see our provisional applications fully fleshed out with patent claims, full drawings. And in a perfect world, if nothing's happened with to change the invention during that 1 year period that Alexandra mentions, we like our non-provisional or foreign applications to really be almost identical to that provisional application. And the reason for that is that the provisional really only benefit is that it establishes a date that you can eventually get back to if there's intervening prior art. So the less that you need to add between your provisional and your non-provisional, the better off you are. Now, circumstances will often dictate that something needs to be put together in a rush, or clients may not have sufficient budget to do a fully fleshed out provisional application. But whenever you have that opportunity, even if it's that you need to file a provisional on Monday and then get a second provisional in on Friday because now you have a little bit more time, you'll be in a much better position. While we're talking about the process, I'll discuss what it costs to get a patent. And this really varies depending on the complexity of the invention and the area of art that you're working in. Some initial filing costs for mechanical patents can range from $5,000 to $8,000. More complex business method or pharmaceutical patents can easily have initial filing costs in the range of $15,000 to $20,000. Keep in mind that's only the initial filing costs. As we discussed, there's a rigorous examination proceeding before the USPTO and other foreign patent offices. So the total costs really are going to vary based on the complexity of the invention, the number of patent claims that are presented, and the number of rounds that you need to go forward with a particular patent office in order to obtain the patent. Additionally, patents are territorial in nature, meaning that if you only file in the United States, then you only have protection in the United States, which for a lot of our clients is sufficient. But for a lot of our clients, there's a concern that if you don't have protection in Europe, you're missing out on the ability to enforce in a key marketplace. So what we need to look at is either within 1 year of that first filing, typically the provisional, or 18 or 30 months if you use what's called the Patent Cooperation Treaty, we need to then look at other countries. And those filing costs can be pretty significant. A European patent application initially might cost $12,000. Similarly, Asian, particularly Japanese applications can be pretty expensive due to the translation costs. But these are all questions to discuss with an attorney because a lot of factors go into that. Alan, how long does it take to get a patent?
Well, as you can imagine from what Brian just spoke to, it doesn't happen quickly. You can get a copyright quickly. A patent is 2 to 3 years. And I want to interject, Brian, two important factors for business owners who have gone through the process and have patents, and they've got the benefit of, for, as you'll hear, for an extended period of time, for 20 years. I was a partial owner of a company with a patent, and the patent was many years, lightly enforced because there were no infringers. There was a very large company that we believed was infringing. We went to have a business conversation, had a business conversation, and the next day they were suing us to invalidate our patent. And the assistant general counsel, and this is one of the 20 largest companies in America, and he said, we'd rather spend $1 million than 50,000 to pay a fee for your patent, because we just don't want people coming around looking for these types of fees. And of course, we were mortified. We went to arbitration and we won. So the point is, you want to be very cautious of putting too much stock in your ability to enforce a patent, because it can be very expensive. And the moment you bump up into someone who has a lot more money than you may find a very determined adversary. So that's a little bit of color that I share, because I see a lot of prospective investments, and they have a patent and they're going to collect fees. And I say that all might be well and good, but it takes a lot of money to defend. So for people who are in that zone, I wanted to share that. It's an important consideration, and I'd be remiss if I didn't share it with the audience.
Sure, thanks. And that's one of the reasons that we've recently started to see litigation finance become much more popular in the IP space, because those costs that Alan noted really can be substantial, and oftentimes for small companies are really beyond what their budget might allow without having outside assistance. So Alexandra, what does a patent allow me to do?
So patent protection gives you specific legal rights, and it provides your business with a competitive advantage over your competitors because it prevents them from being able to make, use, or sell your invention while it's protected by patent. But an important point in consideration, I think, is that you have to understand the flip side is that it does not provide some type of freedom to operate for you. And quite often we'll see this issue come up in other contexts. So you'll see it come up in contract negotiations with a, if you're licensing your product or with some type of service provider where you expect them to sort of promise to you that their technology does not infringe any other third-party IP. And if it does, that they would somehow protect you from that type of lawsuit. So that's a really critical issue, I think. Brian, how do you typically advise clients to think about freedom to operate in connection with patent prosecution?
Yeah, so I think patent prosecution can certainly inform some freedom to operate knowledge in that oftentimes you will bump into patents that may potentially be blocking. But one of the complexities on freedom to operate is you're always considering exactly what is the claim of the patent, which is ultimately defines what the right is. So it may be that a patent application gets cited against your patent application because there's a much broader disclosure. And when you actually look at the claims, they're narrower. And sometimes, we see that in the drawings look really, really similar. And then at the end of the day, you got to look at the claims. The other thing you want to consider is that patent application actually still pending, or are there any child patents that are still pending? So it definitely gets complex. For that reason, oftentimes we try to approach freedom to operate as kind of a continuous process where as we become aware of more information, we consider what impact it has on our client. It's never really a one and done thing. Alan, what's the difference between a patent and a trademark? Pivot a little.
So they're really very different and very unrelated. And we've spoken quite a bit about a patent, the process to get one, and the invention focus. A trademark, which is very prolific on products, it's to remove confusion in the market. So a trademark protects a product from being copied. It identifies it for the consumer, where it's from, who the manufacturer is. There's an implied guarantee of authenticity, of genuine, and sometimes you'll see this often. In fact, you will often see, genuine product. So they're really not related very closely at all. A trademark helps a company monetize its intellectual property on its products.
Great, thanks. And Alexandra, why are trademarks important?
Well, I mean, for some of the reasons that Alan just mentioned, but they're important to trademark owners because they can really help them protect the investment that they've made in the quality of their goods and services, the reputation of their brand, and the trust or goodwill that consumers have come to associate with their brand. And that all of those elements can contribute to your brand value or your price premium. So it can really protect that type of relationship you have with your consumers. On the other hand, it also does provide this type of consumer protection function in that it tries to eliminate any type of confusion. And so if you come to really trust a certain brand, you've tried their products before, you know they're high quality, you won't somehow get tricked into buying a product from another company that you think is associated with the company that you trust, but really it's a lower quality product. So it has, I think, both functions.
Sure, and I think we've all probably had experiences with paying a premium for brands where we have positive experiences, and there certainly are cheaper products on the marketplace, but you're not as familiar with them. So therefore, if budget allows, you may be willing to invest more.
Hey, Brian,
Yeah,
Brian, I
go
want
for
to
it.
jump in here on something that we haven't touched on, and perhaps we should, and that's the licensing of the brands. There are entire companies that have been built on bringing in licenses or acquiring IP around trademarks, and have built entire large companies. And the point is that trademarks can be licensed, and maybe we'll come to this in a little bit. In fact, I'm sure we will. But there is a tremendous amount of money that moves licensing trademarks to unrelated products, everything from Hershey's to there's innumerable products that are licensed based on the trademark and what it conveys. So that licensing revenue stream is important for the ability to monetize the intellectual property of a trademark. And I wanted to insert that at this point.
Yeah, it's a great observation. Thanks. Alexandra, what are some examples of trademarks, particularly, beyond just words?
Yeah, so trademarks can also protect logos or designs. So an example would be the Nike swoosh. They can also protect product shapes, like the shape of the Coca-Cola bottle, the glass bottle. Colors, for example. I think at some point the T-Mobile magenta color was protected. I don't know if it still is. Also, slogans are a really important element of trademark protection, like "Just Do It" is associated with Nike. So any type of word or symbol that serves some type of source identifying function. So basically it allows you to identify the producer of the good or service. So when you see the Coca-Cola bottle, you think of Coca-Cola and you only think of Coca-Cola. That's performing that type of source identifying function.
Great, thanks. Several years back, there was an interesting game. I don't know if it's still available on the iTunes store, which would basically show you different parts of trade dress or trademarks with some things removed, and it was a bit of a guess, see like, can you still identify the brand? And probably a really practical example is, I'm working from my home office. If I see a brown large van pull up, I don't need to see the UPS logo. I know I know what company that is. Alan, is it possible to protect other non-traditional marks beyond just things that we visualize?
So it is, and there's several examples. It can be something in addition to visual. It can be a smell. It can be chimes. It can be there's one other, colors, which I won't touch on that, but I will touch on NBC years ago, many decades ago, had a move to make their brand a large N. And Nebraska took they took offense. They said, no, the big, that's Nebraska. NBC thought better of it, and they went back to their peacock. I don't know whether they have trademarked it or not, but if you think of the chimes, it goes NBC, and it originally was, for those of the audience that know the history of television communications, it originally was GEC, General Electric Corporation. So those types of things are a little off the beaten path. But you can trademark again to identify the source of a product or service and to remove confusion from the market for the benefit of the consumer.
Great,
And
thanks.
I think
Good.
if we have a minute, I think
Yeah,
it could be helpful to also quickly identify what trademarks are not, or what is not a trademark.
please.
And this often comes up in terms of the distinctiveness of the mark. And this is a really complex legal, concept that we're not going to go into. But I think there's a lot of misconception out there amongst business owners. And if you have some type of trademark that is not unique enough or distinctive enough to really distinguish or serve that source identifying function, then it's not capable of trademark protection. So there is some type of threshold that you have to meet there.
Yeah, and there's always, or there often is a tension between
Yeah.
marketing teams and attorneys on this, because from a marketing perspective, it's really powerful to have a name for a product that tells consumers what it is, but that's a tension between trademarks. If you think back to kind of BlackBerry, if you brought somebody in, from Mars who had never seen this and said, what do you think BlackBerry is? I don't think anyone would have said it's a smartphone or a mobile communications device. But of course, as time goes on, those became increasingly ubiquitous, so that most people would either think you're talking about a fruit or a very specific branded smartphone.
Right.
Hey, Brian,
Yeah.
this could be a good spot to talk about trademarks that fall out of being a protective trademark and being a common name for a product.
Sure.
There are many examples which you may be more familiar with, but if you don't sufficiently protect and keep a distinctive product and it becomes a generic term for something, trademarks their value can be diminished and even entirely eliminated. And I have a few examples, but you probably have more.
Yeah. I mean, Kleenex, Xerox come to mind. One of the interesting things that we often keep in mind when we're drafting patent applications is we try to be very careful in the way we describe our clients' products, because there have been cases where the trademark side of the USPTO looks to the patent applications that get published and say, well, the client's trademark isn't sufficiently distinctive because the client itself is actually using it in a generic way in their patent application. So the key takeaway there is that trademarks are adjectives, not nouns. In reality, people aren't quite that pure in terms of how they actually use them, but whenever the company can try to control the usage, that's really the way you want to use your trademark.
So that's like a Kodak camera, an Apple computer, a Kool-Aid soft drink, where they are used as an adjective, although in popular common usage, it often moves the other way.
Exactly.
I have an apple.
Yeah.
And a great way to do that, depending on the size of your organization, is through some type of employee training or awareness. Or if you have any type of brand style guide, you can insert some basic. We used to do when I worked in house, we used to have employee trainings on the proper use of trademarks. And so like Brian said, using it as an adjective, instead of using it you should never use it as a verb. You don't Google something, you use a Google search engine. And some basic parameters like that can be really helpful.
Yeah, absolutely. Alexandra, what are some of the legal advantages to registration?
Sure. So I think maybe we should back up a step and explain that you don't have to register your trademark. to be entitled to trademark protection. So you can use a trademark without registering for it, and it will be protected if it meets the criteria for trademark protection. But filing an application for registration can give you several different advantages. So first of all, it can establish that you have nationwide rights to use the trademark and that your protection extends nationally. Whereas if you use it in an unregistered capacity, generally that your protection is limited to the geographical area in which you're using it. And obviously, if you're an online company, you probably have national rights. But if you're like a restaurant, for example, you could have geographic rights that extend maybe just to your city or just to your state. It depends on how and where you're using it. You have the right to bring an infringement lawsuit in federal court, and it provides certain legal advantages in any type of challenge or dispute. For example, it establishes you've been using it continuously, which is a requirement for trademark protection. If you stop using it for a period of time, and it's a lengthy period of time, you could actually lose your trademark rights. So we often say you have to use it or lose it. And it provides certain damages that you wouldn't be entitled to if you didn't have a registration. I think what most business owners are interested in is they can use the registered R in the circle symbol next to it. And it also gives you certain advantages if you plan on filing in other jurisdictions abroad. So those are some of the advantages of filing for protection with the USPTO. But I'd like to also add that one thing that many people don't often realize when they're thinking about filing for registration is you can do it before you start using the mark. You can do it after you start using the mark, even if you've been using it for 10 years. But that the trademark application process can take a while. It can take a year. And you often should do some type of like pre-filing searches, and those should be pretty broad. So really sophisticated brands will usually have like a long list of marks, maybe like 5 or 10 potential brand names when they're launching a new brand. And maybe they'll only end up with one that's really viable for registration. So those are just some considerations to bear in mind when thinking about registration.
Yeah, those are really good points. And when we're talking with our clients about selecting a potential new brand, what I find one of the biggest reasons for selecting, usually I'd say at least 3, and sometimes it's 5 to upwards of 5 to 10, is that we try to avoid having our clients getting locked in or making too much of an investment in a particular brand that ultimately may not be what is or the best option for them. As with most things in life, different potential brands have warts, and it's much easier to make a calculated decision in terms of which one of those you're going to operate if you haven't already either made a financial investment and started rolling out products, or, as I think I said, more often, an emotional investment because you fell in love with a particular brand, and now your attorney's coming back and telling you, gee guys, there's this other company out there that's using it, and maybe we can use it, but maybe we have a problem with them, or at best we're arguing before the USPTO that we should be allowed to be the 4th brand using this mark because there's 3 other ones out there. So the mark's really dilute. So who cares if there's a 3rd one in there?
Absolutely. When I was in industry, we used to always tell the business that you should learn to love the brand because of that reason. Because yeah, you should start with, a few different candidates, and then narrow it down and learn to love it eventually. But at least, if you take that approach, it will eliminate your legal headaches down the road. It could potentially produce a stronger brand. All of the things that you want.
That's a good phrase, not to keep that one in mind. Kind of the flip side of the reason that Alexandra and I advise our clients to try to take a broad approach before we start clearing things is that one of the benefits of registration before the USPTO is that the USPTO is a really zealous guardian of registered trademarks. So there's oftentimes cases where the USPTO may do a lot of the heavy lifting that a brand owner might do on its own, but it oftentimes will do it even in situations where maybe the brand owner might not want to invest or might not have the resources to invest in trying to prevent someone else from registering. So getting on the register is a real significant advantage. Alan, to pivot a bit, what is a copyright?
Okay, so copyright's my favorite. Copyright is essentially media. Copyright is where I suspect that most consumers aren't spending too much time on the patent or trade secrets. They spend a lot of time on media, and copyright is the legal protection for that media, whether it's literary, a dramatic expression, musical, artistic works. The copyright protects the author of those works, and it provides a bunch of protections. And there are a number of ways that owners of a copyrighted work can use that copyrighted work. Everything, if you think about sequels and prequels and stage shows, they can use that work. Really, they can license it. They can develop derivative works, Mufasa coming from The Lion King. They can make copies. Think of all the DVDs that were sold. They can perform and they can display and they can sell. So copyright protects the creator, the author of intellectual property works that manifest themselves in media. Media, I'm defining here, literary, dramatic, musical, and artistic expression.
Great, thanks. So Alexandra, what kind of things can be protected under copyright?
Really anything that is an original, the words in the statute are actually an original work of authorship. And so that means that you or whoever created it of your own original creation. You didn't copy anything else, and that it can involve really anything that Alan said, a book, a song, any type of artistic work, poetry, computer software, architectural plans. But one thing I think is worth noting is that it has to be, it really protects the expression, your artistic expression of these works, and it has to be reduced to a tangible form, which means it has to be in writing. If you have an idea, it doesn't protect an idea, it doesn't protect facts. Those are things that under copyright law, we don't want to lock up. We need to be able to exchange ideas with people. So that could also mean that, for example, the basic storyline of a book might be considered an idea and not protected by copyright, but the actual expression of the story, the details, the setting, the way that the characters are described, and all of that would be protectable elements. So yeah.
Great, yeah, and to give an example of that, I think most of us are familiar with James Bond as kind of the canonical British spy, but that didn't allow Ian Fleming to just lock up that concept. John Le Carre and other authors have written stories about British spies that certainly have various character arches and characteristics, but they stay away from, the martini, slurping, fast car driving approach of James Bond.
Hey, Brian,
Yeah.
one thing I want to introduce here before it slips my mind is that artistic works fall out of copyright protection. And some of our audience may have been extremely puzzled to see a killer Winnie the Pooh movie that was, I believe, rated R. There is a limit to copyright protection. We haven't spoken to it very much because it's changed in recent decades. But the short version is you get a very long window to exploit it, but it's longer than patents. It's on the order of 75 plus another several decades under some circumstances. But works do fall out, and when they fall out, they are in the public domain. And if you find a work that you like that is outside of copyright protection, you are able to use it, you are able to mangle it. And although that's not a focus here, I did want to touch on it.
Oh, that's great. And I'll have to look up that killer Winnie the Pooh movie. So Alan, what does the copyright allow an owner to do?
So if you're the owner of right, you essentially control the use of that. And whether you license it, whether you hoard it and only use it in your own circle of friends, you control how that copyrighted work is disseminated, and you control all the key decisions around it. Often people have partners in it, and that often leads to disputes. But the short version is a strong, proper copyright allows you to control the work. I'm going to say in its entirety. It allows you to license it. It allows you to sell it. It allows you to preserve it. And I'm not aware of significant inhibitions or restrictions on that.
Sure. And to kind of pick up on Alan said, it's often helpful to think of the IP rights, especially in copyright, but this applies to other forms of IP as well. It's kind of a bundle of sticks. So if I create a novel, maybe Alexandra has experience in publishing, and I want to license it to her to actually create printed copies and digital copies these days, and maybe those are two different operations. And maybe I want to license it to Alan to write a screenplay and eventually make a movie. And you can really get creative by geography, by format, in terms of how those get divided. And there often can be a lot of value in each one of those sticks.
Hey, Brian,
Yeah.
one thing we should touch on, we should also touch on, broadly speaking, you cannot copyright a title. Maybe you can elaborate on that?
Yeah, so you generally can't copyright a title, and similarly, there's limitations on one's ability to get a registration for a title. This is definitely one of those areas you want to talk to an IP attorney, because it makes a difference in terms of whether you have a series of books under the same title versus just a singular one-off work. Alexandra, so we've talked about patents, we've talked about trademarks, and now we're in the area of copyright. How does copyright differ from the previous two?
So patent, typically the word that I typically think of when I think of patent is novelty. When I think of copyright, I think of originality, and it also protects expression. Then thirdly, the trademark, it really protects brand names that identify the source of the goods or services. So they each protect different things. They each have different requirements for protection. And a good example might involve, could be if you were a musician and you invented a new musical instrument that didn't exist before, so it's novel, that could be protected by patent protection. If you wrote a song, that could be protected by copyright. And you could protect your brand name through trademark. So the different regimes can protect different elements. And I think it's interesting how sometimes they can overlap. For example, like a logo could be it could be creative enough to qualify for copyright protection, or, or it could be protected by a trademark. So sometimes these are, when you're really thinking about your IP portfolio as a whole, sometimes you really, there are sometimes strategic considerations in terms of which IP regime you want to use to protect something. So kind of going back to the drug development scenario, most times people think of patent protection when they think of drug development, but quite often trade secrets, which we'll get to later in the presentation, can be used to protect certain elements. So it could be a method, for example, of dissolving a drug's active ingredients, if it's some type of injectable drug, for example, and you might have to choose whether or not you want to protect that by patent or trade secret. And so these are all different considerations that you might have when thinking about the different rights.
Great, thanks. So Alan, do I need to register a copyright like I do if I want to obtain a patent?
So you don't. It's often a surprise to people. Well, my clients developing intellectual property and developing artistic works is often a surprise, but it is a warm blanket to register it. You don't have to. You have a protection from the moment your work is complete, perhaps as a both ending point of one and starting point of another. But it's a warm blanket. It's a warm blanket for the following couple of reasons, two or three for sure. It puts on notice the fact that your work, your artistic creation, has been filed and there are thousands and thousands of works that are filed that never see the light of day, but they are copyrighted. So it creates a public record. It enables you and it reinforces your right to file a lawsuit if it's infringed upon, and it's evidence that it's valid. And that may be an underappreciated one, because there may be people who inadvertently violate your copyright. That has happened. And there may be people who would voluntarily cease and desist with notice that this copyright work is protected and it's been filed. So those are three primary reasons, but you don't have to. And there's a minimal cost. So the short answer is no, but it's a good idea to do so.
Great, thanks. And Alexandra, I often see, or certainly people watching this may see this as well, the term work for hire thrown around like everyone knows what that is. Can you briefly explain what that means?
Yeah, so I think you're right. It's a term that its colloquial use differs slightly than its legal significance. So sometimes people will say it almost as like a substitute for copyright protection, but it has a specific definition under the copyright statute. And basically, what a work made for hire is it has to satisfy certain criteria for something to qualify as a work made for hire. Typically, it's something that's created by someone, whether it's an employee or a contractor, on behalf of an employer or a customer, and it's prepared within the scope of that employment or arrangement. So it could be some type of commissioned work or a supplementary work, a compilation. And basically, this concept, work made for hire, is meant to address who the real owner is, the real author of the work. So instead of the specific creator, it could be, the purchaser or the employer is considered the author of the copyrighted work, and therefore they can file for protection for it. They can enjoy all of the benefits for it. So you'll often see this type of language in all sorts of agreements. You'll see it in employment agreements, and you'll see it in like master service agreements. And typically what you want to make sure, sometimes what's missing from that language is you want to make sure that those agreements, or wherever you're using this concept, that you want to include language that says that if the work does not qualify as a work made for hire under the statute, that the creator of the work will assign their rights to you. So that's a technicality, but I think it's really important to remember, because you do see this concept really, it can come up in so many different contexts.
And another technicality flowing from that distinction is that because if it's a work for hire, the owner becomes the author. This actually becomes really important if you or a client are trying to register a copyright, because it affects the term, which we won't go into because we're running a little tight on time. But there are a number of legal consequences that flow from that. We got a couple minutes, so why don't we talk about trade secrets? Alan, what is a trade secret?
So trade secret has, earlier we talked about, it's a proprietary process or way of developing a product that is not widely known and gives a company a competitive advantage. As was touched on earlier, there's sometimes a bit of a friction whether to attempt to get a patent on that and divulge and possibly have it rejected and having revealed, or to keep it tight within the company or within the confines of those that need to know and need to use it. As Alexandra just pointed out, it's often important for employers to protect their trade secrets, to label them properly, to control their use properly, and to enforce. Enforcement is a little bit more difficult, and I'm going to go to another one because perhaps enforcement, and we're running a little short on time. Enforcement is generally dependent on a couple factors, and I believe it's primarily, in most instances, it's dependent on states. But Brian, I'll let you elaborate on that, please.
Yeah, sure. So there historically, even before I started practicing, trade secret enforcement was really very much a matter of state law. Since then, and I don't remember the exact year, the Defend Trade Secrets Act became available, which provides federal remedies. And interestingly, I was speaking with one of my colleagues yesterday and pointing out that there was actually a recent case in which there was infringement, trade secret misappropriation, both in the United States and abroad. And a U.S. federal court found that even though the action was only brought in the United States, that the damages could reach to compensate for that extraterritorial misappropriation, which provides a much more powerful remedy without the need to potentially bring cases internationally. Alexandra, do I need to register a trade secret?
No, you don't want to do that. You can't, and you lose protection of the trade secret once it becomes disclosed publicly. So once it loses its secrecy, you lose that protection. But I know we're out of time. Maybe I should just add on trade secrets that protection can last perpetually, which is a really powerful benefit, or as long as it remains secret. And the information, you can't really just label anything as a trade secret. It has to have commercial value to the organization or the company. You also want to make sure you have measures to protect your trade secrets, and that goes hand in hand with any type of like information security policies you have, data protection, access restrictions, and you might want to also inventory your trade secrets. Quite often companies, like, it can be difficult to know how to protect your trade secrets if you don't know what they are and you don't know where they're stored.
Yeah. Yeah, the one piece of advice that I often find myself giving my clients is, to build the ark in the Noah sense before the rain. The not having to register trade secrets is both a blessing and a curse, in that you don't deal with the time bars that you deal with in patent applications, but we can often find ourselves in a situation where we're trying to convince a court 10 years down the road that a client took reasonable steps, but may not have really great evidence if the client didn't adopt a policy, if they didn't do an inventory like Alexandra mentioned. And instead, it's just, the CEO saying, well, it's a trade secret and everybody knew it, but you don't have much more than that declaration from that person to really, really prove that it was treated as a trade secret.
And I think the best known trade secret is the Coca-Cola recipe.
I've got one that's actually older.
Really?
Yeah, Zildjian symbols go all the way back like to the 1600s in Constantinople.
Interesting.
Yeah.
Wait, what's the trade secret? How they're made?
It's the formula and the manufacturing process for the metals. That is handed down from father to firstborn son for generations.
Okay. Now we know. A high note to end on.
Yeah, absolutely.
A little known fact.
Yeah, well, the next time you're at an IP trivia night, everybody will now be empowered. Great. Well, with that, I do want to thank Alan and Alexandra for taking the time, and for Financial Poise for hosting this. Feel free to reach out to any of us if you have questions, and we hope to see you back for the later episodes in this series.
Thank you, Brian. Thank you, Alexandra. Thank you, audience.
Thank you.